This reflection continues my examination of the Arizona Code of Judicial Conduct. The previous discussion concerned the preamble. Now I want to look at something perhaps even more important. The section called Scope. At first glance, scope sounds technical and uninteresting. But scope tells us something essential. It tells us what parts of the code actually control judicial conduct, what parts merely provide guidance, and what happens when a judge violates a rule. And once we read it carefully, an uncomfortable question appears. How binding is a binding rule when enforcement of that rule remains discretionary? The scope begins by explaining that the code contains 4 canons, numbered rules under those canons, and comments explaining each rule. It then tells us that the canons establish broad principles of judicial ethics. The rules establish the actual standards of conduct, and the comments provide guidance about how those rules should be interpreted and applied. So far, the structure seems perfectly reasonable. Principles, rules, guidance. But then we encounter something very interesting. The scope explains that when a rule contains permissive language such as may or should, whether a judge should be disciplined depends upon the personal and professional discretion of the judge or judicial candidate involved. Think about that carefully. We are reading a code designed to regulate judicial conduct. But inside that code, we immediately encounter the same concept that dominates so much of the judicial system: discretion. A rule may appear in the code, but if it says may or should, it may not operate as a command at all. Its practical force depends upon judgment. And that creates an obvious distinction. There is an enormous difference between a judge must do something and a judge should do something, and an even greater difference between a judge shall not do something and a judge may decide whether doing it is appropriate. The scope itself therefore warns the reader that not every sentence carrying the appearance of an ethical standard has the same enforceable strength. Then we reach what may be the strongest sentence in the entire scope. It says, "The rules are binding and enforceable." Those are powerful words. Binding. Enforceable. If an ordinary citizen reads those words, what should that citizen reasonably understand? Probably something very simple. There is a rule. Judges must follow it. If the rule is violated, the system enforces it. But the scope does not stop there. Immediately afterward, it explains that not every violation will result in discipline. And suddenly the word enforceable becomes much more complicated. The scope tells us that whether discipline should be imposed depends upon a reasonable and reasoned application of the rules. And that determination may depend upon factors such as the seriousness of the violation, the circumstances existing at the time, whether there is a pattern of improper conduct, whether previous violations occurred, and what effect the conduct had upon the judicial system or others. Some of those considerations may sound perfectly sensible. Not every violation deserves the same punishment. A minor technical mistake should not necessarily receive the same response as deliberate corruption. But that is not really the question I am asking. The question is this: what happens between finding that a binding rule was violated and actually enforcing that rule? And the answer appears to be another layer of judgment, another evaluation, another determination of reasonableness, another exercise of discretion. So we arrive at a peculiar structure. The rule is binding. But violation does not necessarily mean discipline. The rule is enforceable. but enforcement depends upon an evaluation of circumstances. The code establishes standards, but the consequences of violating those standards are not automatic. This does not mean that discretion in discipline is automatically improper, nor does it prove that judicial misconduct is never punished. But it does raise a legitimate question about the meaning of the words binding and enforceable. If enforcement itself depends upon discretion, then perhaps the most powerful part of the system is not the written rule. Perhaps the most powerful part is the person or institution deciding whether the violation deserves consequences. And that brings us directly back to the central problem I have been examining throughout these reflections. Who stands above whom? Does the rule stand above the decision maker? Or does the decision maker ultimately determine how much force the rule will have? The scope contains another important limitation. It explains that the code is not designed or intended to create civil or criminal liability. It also says that the code is not intended to provide litigants with collateral remedies against one another or tactical advantages in court proceedings. Again, this may have an understandable legal purpose. An ethics code is not automatically a criminal statute, and every ethical violation should not automatically create a private lawsuit. The problem is not that every violation must become a crime or a lawsuit. The problem is that the document calls itself a Code of Judicial Conduct, declares its rules binding and enforceable, and then surrounds those rules with language that can make enforcement largely dependent on institutional discretion. But consider the practical position of the person allegedly harmed by judicial misconduct. The code says the rules are binding and enforceable, but the person affected by the violation cannot simply point to the code and say, "The rule was violated, therefore I receive a remedy." Discipline belongs to another process. Whether discipline occurs depends upon further evaluation. And the code itself warns that it is not intended to create civil or criminal liability. So what exactly does the injured member of the public receive from the declaration that the rules are binding and enforceable? That, to me, is the central question raised by scope. A meaningful rule must do more than describe preferred behavior. It must establish a boundary. And if crossing that boundary produces no predictable consequence, then the practical difference between a rule and an aspiration becomes increasingly difficult for the public to understand. Imagine an ordinary traffic law written this way. The speed limit is binding and enforceable, but exceeding it does not necessarily result in any consequence. Whether anything happens depends upon a later evaluation of seriousness, circumstances, history, effect upon others, and the discretion of those administering the system. Would the public still describe that speed limit as an enforceable rule? Perhaps. But they would certainly want to know where the rule ends and discretion begins. And that is precisely what I want to know about judicial ethics. The scope begins by telling us that the rules are binding and enforceable. But it surrounds those rules with interpretation, permissive language, reasonableness, circumstances, disciplinary discretion, and limitations upon remedies. The result is a framework in which written ethical obligations exist, but their practical consequences depend heavily upon human judgment. Perhaps that flexibility is considered necessary. But flexibility has a price. And that price is predictability. If one violation results in discipline and another similar violation does not, the public inevitably asks why. If the answer is simply that different circumstances justify different discretionary conclusions, then the code may provide standards while still leaving enormous power in the hands of those interpreting and enforcing those standards. That leads me to the question I believe every member of the public is entitled to ask. When the code says its rules are binding and enforceable, what exactly guarantees the binding, and what exactly guarantees the enforcement? Because without a reliable answer to that question, those two powerful words may promise considerably more than the system actually guarantees. And perhaps that is the most important lesson hidden inside the seemingly technical word: scope.